This does not justify the greatest evil in the world, the war. War destroys everything that is good. We may give every help to Afghanistan, but not dead women, children or men. These are human beings too, and the Germans are responsible for them. I say every help for Afghanistan and for the women in Afghanistan, but no dead men, women or children. In a really perfidious manner, the principle of subsidiarity that is so important in Germany has been eroded by the Federal Constitutional Court, for only the Bundestag and the Bundesrat may file a lawsuit claiming the observation of the subsidiarity principle in future, and they can only do so within a period of 6 weeks. And if they are late, no complaint can be lodged after that. Particularly for that reason, the German constitution will be amended, and that means the principle of subsidiarity is of no value. These are dire prospects for the European peoples, despite the judgment that has defended the national principle by strengthening the right of withdrawal after all. That is the last resort for the right to self-determination of the European peoples. And the economic crisis, which will even worsen, will demonstrate that. At least we will no longer have a Europe of freedom and a Europe of right and of security, contrary to the euphemistic term space of freedom, space of security and right in the treaty. All these are merely short remarks on the judgment. Many have praised it as a very great success in terms of constitutional dogmatics. Of course, that's true. But with respect to the European issue, it is of little value, and as soon as the fog has cleared up, everybody will realize that nothing has changed. The Lisbon Treaty has been accepted, but it is true that it has been changed in various respects to the FCC's interpretation. But one thing is for sure, you cannot challenge the treaty on the grounds of international law, because, to a certain extent, there is another treaty effective in Germany than in Austria, due to its different interpretation. For the Federal Constitutional Court is doing nothing, rather the opposite. In Austria, the limited priority is given to the union's right vis-à-vis the national right in violation of the irrevocable constitutional principles. The German court does not do that. They draw limits far away, but the limit is nevertheless there. And certain regulations of the treaty have been interpreted by the FCC in such a way that they are now meaningless. I cannot go into more details now, but I will answer your questions later on. So in fact, the interpretation goes far beyond, so that you could have the impression that the threshold of the different interpretations of international law, which international law tolerates, that is the threshold to dissent, the contrary of consent, is transcendent, actually is no longer a treaty, because everyone understands something different when reading the texts. However, I think in practice you could not enforce this view, because one is very tolerant in this respect, and anyway, we have a Europe of different speeds. Things are different everywhere. The monetary union has not been established everywhere, and much more. Poland, for example, says that Polish constitutions overrides European legislation. Very good, very good. We should do the same. This also seems to be the basic conviction of Republicans in Spain, and it is the right one. The Irish people can vote and have their own constitution in mind when voting, and then they can try to put it into effect.
Noch etwas zu Irland zu sagen, versuchen. Ich denke, das irische Volk.
I think the Irish people are deceived on a large scale. This has already been explained by Mr. Dalton. They pretend to make changes, but if you have a closer look, you will realize that there are none. if you have a closer look at the text and you do not only read what is written in the newspaper. First, have a look at the form. It is not a resolution passed by the European Council, but by the united heads of states and governments. That is not the same as the European Council. If the European Council assembles, those are the heads of states and government. The President of the Commission is present as well. But it is true that also the heads of the states have got a certain status in international law. On that occasion, the representatives of the states assembled, they did this intentionally, that they, and not the European Council, passed this resolution containing the concessions for Ireland. So this is definitely an act under international law, not an act passed by an official body of the European Union. Treaties are always agreed upon insofar as the heads of states and governments, or the foreign ministers, or the respective ministers sign it at first. However, this legal act, or rather this act, cannot change the treaty, because it is regulated in Article 48 of the current EU treaty how to proceed about changes or amendments. This is a very special procedure, a complicated procedure that I cannot explain in more detail now, but it presupposes the contents of the member states according to their constitutional regulations. That is the ratification which has not taken place up to now. They say that this ratification will take place after a protocol has been set up. This text, the Irish Special Conditions, is to be passed in a protocol as soon as Croatia is joining the Union. Apart from the fact that the burdening of the Croatian Treaty of Accession with such a general agreement, a protocol, may be questionable with respect to international law. But it is likely that international law is interpreted very widely and overrides the doubts concerning the European Union. You cannot achieve much this way. However, Croatia has not joined yet. There are also some concerns there, and if I'm not mistaken, there are also some doubts raised by Slovenia. So, this access of Croatia has to take place at first. So, that's a long way off yet, and things may be altogether different then. As long as the protocol will not be ratified by all member states, there will be no security for the Irish. For this resolution of the heads and states of governments is simply nothing but a political declaration of intention, because it cannot alter the treaty formally. As there are political statements of intentions in the treaty anyway, this is avowedly dogmatized by the Federal Constitutional Court. They are not at all legally binding, and if they write here that they will come into effect with the Lisbon Treaty, this is simply not true. This is not what it says. It will come into effect, will be effective. Yes, it will be politically effective, but it can never achieve another effect with regard to international law. Since it is generally acknowledged that the treaties, and it is the Treaty of Nice which is to be changed and which is existing law, can only be altered in a very complicated procedure, and not just anyhow. Another point is, and that might be a little difficult, if I look at the text of the resolutions, nothing remains, simply nothing. I have to read the German translation. Neither the regulations of the Lisbon Treaty, which grant a legal status to the EU Charter of Fundamental Rights, nor the regulations of the treaty in the fields of freedom, security and law, touch on the scope and application of the protection of the right to life, as it is proclaimed in Article 40, paragraph 3,